So what's a personalised housing plan and what use is it in the real world when you make a homeless application? Now, if you have made a homeless application, you'll be familiar with this term, or a PHP as it's often referred to. And effectively, these are documents which local authorities create as part of their initial duties, or they should do. Often they don't, but they should do very early on in the process when you make a homeless application. Either when you're threatened with homelessness, which means it's likely you're going to be homeless within the next 3 to 6 days, or if you're actually homeless already. So the prevention duty would kick in if you're threatened with homelessness, and the relief duty would kick in if you are actually homeless, once the council satisfied you're homeless and eligible. And as I say, very early on in the process, the council need to carry out what's called a Section 189A assessment. And actually, councils have been criticised for taking more than 2 weeks to do that. So there's a case, I think involving Hackney or something, I'll put a link up on the screen, where basically the LGSCO criticised the council for taking 10 working days to actually come up with a PHP, because the whole point of a PHP is it's supposed to set out what the council's going to do, what you're going to do in order to either remain in your home or find an alternative accommodation, and kind of just make sure you don't become homeless. And if you watched this channel before, you'll know I really dislike the Homelessness Reduction Act, which is where this bit of legislation comes out of. The actual law around PHPs is ridiculously convoluted. I'm not really going to go into too much detail, because as a homeless applicant you're going to see one side of it. As a housing officer, you're obviously going to see a whole lot more of the inner cogs, and they are, as I say, they're just ridiculous, to the point where when it comes to something like being found to have unreasonably and deliberately refused to cooperate with the plan, that is something I will talk about in the video. But from a housing officer's point of view, that's just a nightmare. The complexity of that process to actually go down that route probably means that most housing officers just won't bother. That would be my view anyway. But in terms of actually making a homeless application, PHPs can be very useful. When they first came in, I just kind of thought they'd just be a tick box exercise. And they often are. You know, often it's just a template document that the council officer fills in for you. Often you won't even be aware that it's been filled in sometimes, and it would just be kind of very generic stuff like go and find private rented accommodation in the area, that sort of thing, which is, you know, I'm sure most people have tried to do that already. So what we're seeing increasingly in case law, I say right now, it's actually been going on for a few years, is that actually PHPs can be very useful when it comes down to challenging the suitability of accommodation that the council then offers, because there's a kind of a cascade of events that have to happen. And I use that word cascade. If you want a really good article about this, check out Giles Peaker's blog Nearly Legal and search for the term cascading unlawfulness, because again, that was a case where the suitability of an offer of accommodation in Gravesend from Lambeth essentially was found to be unlawful because Lambeth had never actually done the assessment properly in the first place. So everything they then did was essentially going to be found unlawful, because they just had no way of actually knowing what they were doing. So as I say, it kicks in early in the process. It should be done early in the process anyway, and you may not be aware of what's really going on, because often what happens is you make a homeless application. As I've advised in a different video, the best way to do that is in an email, so you've actually got proof of what's happened. But fairly early on in that process, you're going to be invited in, most likely, either a face-to-face appointment or maybe a telephone conversation, depending on the council's policies. And in that meeting, which will be about an hour long, depending what, you know, what's the story, the housing officer will be making inquiries into things like priority need, intentional homelessness, local connection, that sort of thing. And they'll also be carrying out this Section 189A assessment, and then coming up with this personalised housing plan, which essentially, as I say, sets out the so-called reasonable steps that they're going to take and that you're supposed to take in order for you to, you know, prevent or relieve your homelessness. That's the kind of wording of the law. And as I say, they might not use that specific word, so you might not actually be aware that's what's happening when you go into those meetings, because they'll kind of ask you loads of questions, they'll be taking lots of notes. But what is likely to be happening there is they are asking, as part of the whole assessment, they're looking at these 3 questions of: why did you become homeless? What type of accommodation do you and your household need? And what support do you need to maintain that accommodation? And as I say, housing officers will be using fairly, you know, kind of templated documents basically, so they put in a little bit of information here and it kind of automatically populates it with suggestions of reasonable steps. So they're not really personalised. And I guess I'd say at this point that increasingly I'm just frustrated. I mean, I was never a fan of the Homelessness Reduction Act when it came in, but just looking at how ridiculous this is. Essentially, this is what happens when the government puts forward legislation without asking people who've been homeless what they think. Because I guarantee you, if you'd asked someone who's homeless what do they think of this, they'd have said this is ridiculously complicated, no one understands what's going on, that's not a good thing, surely there's a way to simplify it. And also, the government would have been very sensible to take on board psychological input, because lots of the stuff within the personalised housing plan is essentially it's basically built on the fact that the council's going to threaten you into it. They're basically going to say, if you don't follow these steps, then we're going to end the prevention duty, then we're going to cut down the amount of options you have. So it's never really a collaboration, although they kind of use that sort of language. There's this real ambivalence where, they kind of talk about, it's about, make every effort to kind of find out what the applicant wants. But at the same time, it's all set in this kind of this framework where if you don't do what you're told, the council is going to basically make it difficult for you and try to end their duty to you. So, as I say, I think government need to really kind of take on board this kind of criticism if they're ever going to set up legislation in future, because they need to take into account, they need to really kind of in a structured way take into account the views of people who've been homeless and have gone through the system. I could talk more about that, but I won't right now. So anyway, personalised housing plans. Also bear in mind that housing officers probably resent them, because what actually happened with the Homelessness Reduction Act is it didn't actually reduce homelessness at all, but one of the things it did was increase the workload of housing officers. So it just basically gave them another set of things they had to do, and they kind of know that often it's going to be fruitless, it's often going to be a waste of time, because if you're going to tell people, go and look in the private rented sector for accommodation, everyone knows that there's hardly any around and that most applicants will not be able to do that. They kind of know it's setting people up to be frustrated and to fail. So so that's kind of the environment you're going into this process. It often doesn't help at all, but you can use it, as I say, if you're going to challenge the suitability of accommodation later, because you can kind of use the information you give them to make sure they then actually properly assess the needs of you and your family. So as I say, the Section 189A assessment is done, and often at the same time in the same meeting, what's really happening is that they are then making these reasonable steps, and as I've said, they're not really a collaboration, because you can't actually challenge the reasonable steps that you're supposed to take. You can challenge the reasonable steps they're supposed to take, but you can't challenge the reasonable steps you're supposed to take. Now, I guess indirectly you can challenge it if they were to try and say that you've unreasonably and deliberately refused to cooperate, because you can kind of go down a review process, but I promise you do not want to be in that situation. So, as I say, the whole premise of this thing is ridiculous and just unhelpful, and when you're working with people who probably don't like professionals in many ways, because they probably had lots of bad experiences of bureaucracies and so on, this is just a terrible way to kind of advance some sort of rapport and kind of some sort of relationship built on trust. It just undermines everything. And the reasonable steps that they can set are kind of broken down into mandatory steps. As I say, that word mandatory in itself is kind of quite a scary word, not going to kind of invoke cooperation, and then recommended steps. And the mandatory steps, as I say, might be things like look for private rented accommodation. It might be something like, kind of get debt advice, something like that, which probably more helpful. It can include steps about kind of applying for other benefits that you might not be getting at the moment, which would be a really positive one. And it could also include, and this is where I think it gets really problematic, things like, say you've got a mental health issue, they can kind of mandate that you engage with mental health services, which is a terrible way of eliciting any kind of progress. I mean, okay, fine, make it a recommended step, but if you make it a mandatory step, which they can do, again, what sort of behaviour does that lead to? That's basically going to at best lead to someone going into mental health services without actually wanting to be there. And having worked in drug and alcohol services before, I can tell you the worst thing on earth is when you have someone coming in because they have to, because some professionals told them to, because they don't want to do anything meaningful at that point. They're just, they're not in that headspace, and so it becomes a waste of everyone's time. They're just kind of jumping through a hoop to satisfy someone else. So that's the kind of reasonable steps that can be taken, and as I say, you can't actually challenge them directly. I think the only kind of defence you've really got is the fact it is so difficult for housing officers to try and go down that route of saying that you've not cooperated, because there's a whole bunch of steps they have to take to do that. Because, for example, they've got to kind of give you a written warning to say what the implications are if you were to refuse steps. Now, if you are found to have unreasonably and deliberately refused to cooperate, that will end the relief and prevention duties. If you're in priority need, then it would potentially mean that there would be additional duties to you, but what it would also do is it would basically dilute the kind of the goodness of the main housing duty. Because whereas if you owe the main housing duty because you're in priority need, you're not intentionally homeless and so on, in that situation you would get at least a 12-month assured short hold tenancy in the private rented sector, or you'd get onto the housing register and be able to kind of bid for social housing. By being found to have been uncooperative in this process, essentially that will kind of go down a step to the final accommodation or a final Part 6 offer, which is only a 6-month assured short hold tenancy or an offer of social housing through the housing register. So there is that kind of danger that if you're found to, or you're believed to have not cooperated unreasonably, then that's the sort of thing that can happen. There are some defences against that. So, for example, if you can evidence the fact you haven't cooperated because you're having some mental health difficulties, for example, or maybe substance use issues or something like that, then those are kind of defences. But again, this is all a distraction from actually getting housed. This is just kind of a process you do not want to get bogged down in. So I guess the most positive thing I can say about this is that you can use it as a basis to challenge subsequent decisions that accommodation is suitable. And that is why I guess the thing I'd say in terms of practical terms of what you'd want to do is when you're having those initial set assessments, when you're emailing the council to actually trigger a homeless application and subsequent emails, you want to make it absolutely clear that you have, kind of fully communicated both the things you need and the things you would prefer in terms of what the council then does. And this idea of needs versus wishes, that's the kind of language they use within the law, is a little bit murky. Lots of councils will basically dismiss needs as wishes. So for example, there's an interesting case called XY v Haringey, where effectively, it's probably worth going into a bit of detail. So essentially, if I understand it correctly, the mother was subject to a knife attack, and essentially I think it sounds like she was kind of stabbed through the hand or something. And she lived in Haringey, but her family lived over in Enfield or something. I might be getting the districts wrong, but I'll put a link up on the screen, you can check it out. And as a result of the injuries resulting from this stabbing, she was unable to grip properly with one of her hands, which made it unsafe for her to kind of carry children up the stairs, for example. It also made it difficult for her to help her kids in the shower, so then they need to have baths. And as a result of those kinds of things, she needed to be near her own parents, who lived, I think, as I say, in Enfield or one of the districts that she wanted to be clear, so that she wanted to be near. So effectively what Haringey did was that they kind of recorded those as wishes and said, well, yeah, she would rather be in the area near her parents, but it's only a wish, it's not an actual need. And it looks like they took 4 attempts to do this assessment properly. I'm not quite sure what actually happened in the meantime, but effectively, ultimately, they did actually manage to do a proper assessment where they correctly identified that there was an actual need to be near her parents so her parents could help with the care of her children. And I guess that's a good example of the kind of thing that if you're going to advance an argument that you need something, you're going to need that. I mean, in that case, it would have been a case of medical evidence, that sort of thing. But you're going to need some kind of evidence from professionals or some kind of something concrete to make that point. So you need to kind of show why it is it's not just a wish, it's not just a preference, it's actually something that you need. So in my own casework in Bedford, I remember a family who, Bedford's not a terribly big town, it's like 150,000 in the borough, something like that. But the council initially tried to house her on the other side of town from her support network, from her family, from her parents. And one of her children, in fact 2 of her children had autism, but one of her children in particular just kind of would really kind of become very, very distressed and run off if they were kind of tried to go on public transport. And so that we raised this with the council. They kind of again said, oh, that's just a preference effectively. And so we had to get into this kind of big argument with them, but ultimately eventually they correctly said, okay, no, that is actually needed. And we used kind of evidence from the school, evidence from the kind of autism assessment itself to evidence the fact that it was not reasonable. It was not reasonable to put them on that side of town when they just weren't able to kind of get across to see their family and vice versa. And ultimately they were housed on the right side of town. But again, that's the kind of thing you're going to need. And there's a little cynic in me, and I'm not sure how helpful this is to say this, but there's a cynic in me that says, sometimes at least, if you tell a council that you want something, they'll kind of give you the opposite thing just to put you off. So if you say, I want to be on this side of town, they say, well, sorry, there's nothing there, we're going to put you on that side of town. I think that kind of thing does happen. I'm not saying every housing officer does it. And in one sense, it's not probably very helpful for me to say that because I'm not quite sure what you actually do about it. Because, you ultimately, I think, you want to express what your preferences are. But certainly just bear in mind that certainly a small number of housing officers will essentially just kind of do the opposite just to kind of frustrate you and make it as unappealing as possible to make a homeless application and pursue it, which is, again, that is something which we do see in the sector elsewhere as well, where they just kind of make temporary accommodation as unpleasant as possible in their mind, so the only the people who really need it actually get it. But that's obviously not what happens in the real world. So things you want to raise in the interview, things you want to raise in writing really in the initial emails you send, are any disabilities you and your household might have, kids' schools, particularly if there's they might be having difficulties at school where it's important that they remain in a school, that they kind of remain stable. It might be things like support network, as I say, but again, you need to probably go further than just say it's important to have a support network, because that is a valid thing, but it's probably not enough to qualify as a need when it comes to a housing assessment. Once you've fully communicated all of those needs and preferences, you want to make sure that the council has actually correctly assessed those things, because what you might say is, like, well, I need X, Y and Z, and then they write down client would prefer X, Y and Z. You need to make sure that that's not happened, that hasn't happened, because again, what often happens is someone says something really obvious, like, I'm a wheelchair user, I need to have a ground floor flat or accommodation with a lift, something like that, and the housing officer then records it in their plan, but no one ever actually looks at that plan ever again. So when it gets to the kind of the accommodation team or something, when it's a different area in the council, no one bothers to look at that initial assessment, and they start offering stupid properties like, 3 flights of stairs. That's the sort of thing which is obviously unsuitable. Obviously that's an unlawful thing to do, but you don't want to get into that situation. You want to try and make it as easy as possible for the council to actually follow the law by having a very clear assessment of the different criteria that you and your family need when it comes to the suitability of accommodation. Other than that, I'm not quite sure what use PHPs are. I'm sure there might be some other stuff which can be useful, but I don't, as I say, I've not seen it really kind of happen in practice. The only times I've seen it is in these cases which involve suitability challenges, where you're essentially basing your argument on the fact that you'd already told the council about X, Y and Z needs, disabilities, whatever, and they just basically ignored it and just kind of offered you something which was obviously going to be unsuitable. So I'm hoping that's helpful. In conclusion, make sure you are very, very careful to communicate everything you need to communicate, particularly when it's about sensitive things. So, again, we haven't really talked about domestic abuse in this video, but where, for example, you're scared about certain areas because the perpetrator might have connections there, you need to be saying that. I appreciate it's uncomfortable to say that. Again, I'll just put it in the email, in the initial email, just to say this is the situation, this is kind of what I'm afraid of, this is where the risks are, that sort of thing, just to make sure that's all in there. But once you've done that, I think the PHP just becomes this tick box exercise. And I guess, in my opinion, the most important thing you do is actually make sure the council accepts that you're in priority need if you're in priority need. Because if you can do that, you massively increase the chances of getting an offer of accommodation that's going to be halfway decent. As I say, that's more important than worrying about the detail of the PHP, except where you've got these kind of potential suitability challenges. Because what you don't want to be in is a situation where you're having to raise issues down the line where they offer you an accommodation and you say, well, that's not suitable because of X, Y and Z, and they're like, well, why didn't you tell us that before? That kind of undermines your position. So you want to make sure you've kind of put that stuff forward. And again, I'm not sure how helpful this is, because it just requires a bit of guesswork, but I would also not over egg it. So I see people kind of give a list of like 10 different bullet points about why something, why the council's offer is unsuitable, and 2 of them are really valid, but the other 8 are like just silly. And actually what that does is it undermines your position, because the council officer looks at it and says these are silly, and they kind of throw the baby out with the bathwater, and they actually dismiss the ones which do have some weight to them. So I would kind of make sure that when you're asking for your needs, just stick to things which actually definitely are needs, and maybe do a little bit of research in terms of those cases I raised are the kind of things which would be considered needs. Because if you get into an argument with the housing officer saying, well, I want to be on, kind of on with a sea view or something, I know that's a silly example, the housing officer is going to get tired of you, basically, and you don't want that to happen. You essentially want to elicit sympathy with the housing officer if at all possible, because they've got an impossible job. They do. They could do stuff about that, which they don't, but let's face it, they do have an impossible job. So you want to kind of just work with that and try, as I say, try and elicit a rapport. Try not to be difficult. Try not to be make their job any harder than it needs to be. But at the same time, don't forget that you have your rights, and actually, you're absolutely justified to fight as hard as you can to get a good offer for you and your family. So yeah, hopefully that helps. If you've got any questions about it, as always, stick it in the comments. I'll take it to the weekly live stream every Thursday, 7:30 PM. You don't have to watch it live. You can watch the recording. But if you do turn up live, then you can kind of obviously have a bit of to-ing and throwing within the actual session. So we just basically kind of take these questions anonymously and discuss them. And in those discussions, you can often get to the nuance and the kind of the critical bits of it. And if you find this stuff interesting as well, I guess just to mention, we do online training. It's very reasonably priced and gets ridiculously good feedback. Just people love it. You'd not imagine that about a training day about the law. But I make it very, very interactive. I kind of base it on real life cases and kind of approach it from the ethical angle, not just the legal angle. So I think, as I say, it's just, I think, it works really well. And equally, if you've got a team that you want to get involved, we obviously do kind of in-house training as well, either in person or online as well. So again, just get in contact if you're interested in that sort of stuff. But yeah, PHPs, I'm hoping that some of that stuff was useful. Don't hold your breath with PHPs being the answer to everything, because they're not. As I say, priority need is more important, but they can be useful, and I guess there's nothing to lose by making sure you're communicating your needs properly. early on in the process.